It's my honor now to introduce Mr. Todd Hunter. He is the director of the National Security Law Center and a lecturer at Georgetown University Law Center, where he also teaches courses on counterterrorism and hybrid threats. He retired from more than 20 years of service in the U.S. Navy, serving as a judge advocate general. He also served as the Deputy Assistant Judge Advocate General of the Navy for National Security Law. He has extensive experience supporting the special operations community and served in several overseas assignments, including Afghanistan, Qatar, and Iraq. Thank you, Todd, for joining us today and telling us about the legal challenges in information and cyber operations. Thanks, Todd.
Thanks a lot, Joe. I appreciate the kind introduction. As the title of my presentation states, I'm going to discuss some of the legal challenges in information and cyber operations that we're facing today. And there's a lot of overlap in challenges that are also affecting intelligence activities, because both information operations and cyber operations are intelligence intensive activities. And so the need to use technology for collection, for collecting on individuals and countries, as well as collecting on how tech is being used to threaten our interest, is facing some legal challenges. Before we start, though, I noticed that I think during Davy's presentation, Holly asked a question about to what extent is the IC's legal framework fit for purpose when it comes to OSINT. Let's see if I can. I just put a link in the chat there to an excellent article that was published in our Journal of National Security Law and Policy just about 2 or 3 weeks ago by Steve Szymanski, who's an Army JAG, where he's discussing the purchase by the Defense Intelligence Agency of publicly available information. And in his article, he does an excellent job of describing those challenges with regards to the use of publicly available information for intelligence purposes. So if you're, Holly, if you're interested in that, I'd recommend you taking a look at that. I'm going to share my screen here. I have a couple of slides that I want to use as just kind of, examples of what I'm talking about. So hopefully you'll be able to see it there. I don't know, Joe, is that showing up for everybody?
Well, it's showing up for me, so I
Okay.
assume it's for everybody.
Great. So just a little framing first. International law has really been established and developed to govern the relationships of sovereign states. Its purpose was really to protect the sovereignty of the state in its own domestic affairs and govern how states pursue and protect their interests with regard to other states. Obviously, it also deals with how states resolve their disputes and disagreements. It was really geographically focused. It was focused on the state of affairs between states, in that the legal regime that applied to those state activities were pretty clearly divided between activities that took place during peacetime and those that took place during war. Obviously, as interests change, as power change, stress is put on this system. And to kind of bring that back to what Jack Shanahan mentioned this morning, saying that we are in a shift from an industrial to an information age. The law is still trying to catch up to this shift, right? So the other point, kind of to frame our discussion, I want to mention is that law is fact dependent, right? It is not something that, at least for our domestic law, we'll talk a little bit more about this, that we can just state the law and that it would apply in every circumstance. And the international law in some ways is much the same. Again, in determining, is this state in a state of peace or a state of war? So how is this new technology, especially in information operations and cyber operations, being challenged or challenging the current legal regime? Oh, I'm sorry. There we go. The so you can see here, this is a chart that kind of lays out both the threats that states face, as well as the reactions that they can take to those threats. So I mentioned before, right, that international law was really developed to apply in two clearly different factual situations, whether the states are at peace or at war. If a state suffers an armed attack, then it's permitted to use force in self-defense. That's pretty easy. It gets a little bit more difficult if it's considered a use of force, which is kind of it's not quite as much of a threat or as drastic as an armed attack. And so, what a state can do in response to a use of force is also set out in international law. So how does especially cyber operations fit into this? How does it challenge this? Well, some of you may have heard of the Talon Manual, right? So a group of experts got together in Tallinn to, at first, discuss and try to give examples and explain how the law of armed conflict applies to cyber operations. A few years later, they came out with the Tallinn Manual 2.0, where they did the same thing with international law more broadly. That is peacetime international law, kind of what you see on the left-hand side of this slide. How does cyber operations affect the sovereignty of a state? When would a cyber operation be a prohibited intervention in the domestic affairs of a state? And they describe that. The Talon Manual obviously isn't law. The experts that put it together tried to explain and lay out examples. And perhaps the only thing they agreed on, and that the states who have looked at this have agreed on, is that international law applies to cyber operations. So, if a cyber operation rises to being the level of an armed attack, then the law of armed conflict applies to that operation. States must comply with it in carrying it out. States must comply with the law of armed conflict when responding to it. The difficult part is, again, determining the facts. What type of cyber operation is an armed attack? Despite what we see in the media that largely reports every type of malicious cyber activity as being a cyber attack, the word attack has a very specific meaning in international law. So, in fact, it has to have some sort of effect that is akin to a kinetic attack. So the experts in Tallinn, said that, you essentially have to have some sort of death, injury, or destruction as a result of the cyber operation for it to rise to that level of being an armed attack. The examples that they gave, and really the only examples they could agree upon, were things like a cyber operation directed at a dam that causes the dam to fail and break, and a flood resulting killing people, or a cyber operation that either takes the air traffic control system offline or changes it, causing airplanes to crash, again, killing people. That would be an armed attack. But really anything below that, they weren't able to agree upon. And I would say that, again, the law of armed conflict as it was developed was really developed to protect industrial era interest. What they were concerned about were troops from one country taking the areas of another country, causing death and injury within a country's population. But things like just the pure destruction of information that could have very adverse economic effects, widespread health effects, that is in this gray area where experts cannot agree on whether a state who suffers such a cyber operation would be authorized to respond with force in self-defense. So this is this gray area in the law of armed conflict and international law that cyber operations really challenges. When we're talking about information operations, we're really looking at this left-hand side of the chart and those interests in existing law challenging that area. So again, we have a principle of non-intervention in international law. That is that states should not intervene or may not intervene in the domestic affairs of another state that are within that state's sovereign rights to control. So things such as choosing an economic system, a political system, elections, carrying out the law enforcement and criminal enforcement actions within their own state related to their own citizens. Those are matters that are, again, left to the sovereign state to control, and any interference within those is a violation of this international legal principle. And then we have a violation of sovereignty. And this, again, is the area where there is a debate amongst the experts as to what type of information operation or cyber operation would violate this principle of sovereignty. And that is really a disagreement over what this concept of sovereignty in international law is. Is it a principle of international law that really just is the foundation for the non-intervention principle, or is it actually a standalone rule that can be violated? If there's no agreement on that, then it is very difficult to agree on what permissible reactions a state may take when they suffer a violation of their sovereignty. And you can see here down at the bottom, again, these are the legal measures that the international community and international legal experts agree can be taken by a state who suffers a violation of one of these non-intervention violations or a violation of sovereignty. And again, you can see that's not a use of force. It's basically peaceful measures that are either unfriendly, cutting off air traffic between states, declaring diplomats persona non grata and making them go back to their home state, cutting off diplomatic relations, or it may be a countermeasure, which is an illegal act, but done in response to an illegal act. And we can get into that more later if you have questions about that. But if we take the 2016 information operations directed against the United States by Russia, again, is that a violation of the principle of non-intervention? Were they intervening in the electoral system of the United States? On its face, it certainly appears so. But again, it has to be a coercive act under international law. And so the line that most people draw is that if there is some sort of cyber operation that actually changes results of votes or destroys the ability for the state to count the votes, so taking all the voting machines offline, for example, or changing the tally after the fact to change the results, that would clearly be a violation of the principle of non-intervention. But merely trying to influence citizens either to vote a certain way or to not vote at all, that would be an unfriendly act, but would not be a violation of this principle. So the state would not legally have much recourse other than, again, to resort to countermeasures or some sort of domestic legal measures. You could prosecute people for Foreign Agent Registration Act violation. You could prosecute people for campaign finance violations if those exist and you can prove them. But there's really no international recourse for the states who suffer this activity. So I'll go on to my next here. Next slide. So if we talk about the domestic law, all right, we'll go here. The domestic law, again, is fact dependent, right? And the purpose we can see really is to balance governmental interest and personal liberties and rights of citizens. Those interests, the balancing of those interests shift as threats change and as society changes. Dwayne had a comment about how our laws limit the use of certain individuals for intelligence activities. Well, those were developed, again, as some of those interests shifted. Who does the state want to protect against any type of possible recrimination or attack against who do we want to make sure is protected when they're carrying out whatever activities they may be in different countries. So again, that has changed and those limitations have been imposed, sometimes because of past abuses or just because our interests are changing in those areas. The domestic law, again, is really focused on citizenship. It's on or residency and also geography. So it's a very industrial age concept, again, trying to apply these laws to technologies that allow people around the world to communicate directly, to take activities that before the inventions of some of these technologies would have required physical presence in this country. Those are all, again, challenging those concepts in those legal boundaries that have been set. It's also obviously a system of checks and balances. One that when we're talking about government activities, so here we're kind of switching to not what can we do in response to some sort of aggressive action against us in the information environment, but how can we carry out our own information operations and cyber operations to pursue our interest? Well, in that case, obviously, we have a system where we have to make sure that the government agency who's going to be conducting the activity has the authority to do so, that we follow the established oversight regime, and that we make sure that we follow any requirements or restrictions that have been put in place either by Congress via statute, via the Constitution, or via regulation within the executive department. And so normally what we do here is we ask, what is the purpose of the activity? And that will then drive, again, who would have the authority or who would we look to have the authority to conduct that activity? So the one area, again, kind of gets back to Holly's question with regards to open source intelligence and how that's defined in within the US government, particularly within the Department of Defense. Right? Open source intelligence is collected pursuant to an intelligence requirement. It's analyzed and it's then distributed to those individuals who have the intelligence requirement, where publicly available information is defined more as being, again, publicly available information that is gathered to support operational needs, to support an operation. So again, if you're going to do an information operation, you're going to need to collect information on your target audience to see what type of media would be most effective. You're going to analyze what type of message would be most effective. And then you want to monitor that to make sure that your message is resonating, is being effective, so that, or that you can adapt it, change it to make it more effective if it's not working. So determining that purpose when the underlying activity is essentially the same, the tools being used to conduct that activity are often the same, challenges the lines that have been drawn via law and regulation on who may conduct that activity. And obviously in the United States, when we look at domestic law, when we have a question as to where those lines are, who has the authorities, whether those boundaries have been violated, we look at the courts who then apply and interpret the statutes. Again, I said before, law is fact dependent. At least in the United States, our courts do not offer advisory opinions. Some countries, courts will do that. They only decide matters in controversy. And I'll use an example here in a couple of minutes. And so the United States, kind of the gold standard would be, do we have a Supreme Court opinion that addresses this issue on which we can analyze the law applicable to the current facts and issue an opinion? The problem is those Supreme Court opinions aren't going to come out until at least 5 years after the event, by which time you're on to the next generation of technology, or perhaps two iterations of the technology. So it's already outdated. And you can see this in a couple of these cases that you see listed on at the top there. This is kind of an overview of the Fourth Amendment doctrine in the U.S. law. So again, if you're looking at Fourth Amendment, you may say, well, that's a criminal matter. But if a lot of our intelligence requirements are now going to be more domestically focused, if the threats are not limited to foreign sources, or if our foreign adversaries are now using systems within networks within the United States, we're going to have to look at these issues and look at some of the privacy protections that have been put in place, in opinions by the courts, when we're trying to decide how can we use this technology to either conduct our cyber operations or collect intelligence. And so I think the two quotes that you see here really do a very nice job of setting out, I think, the two poles of the debate when it comes to the use of technology for intelligence gathering and for criminal investigations, right? And so the first one there, from U.S. versus Jones. This was a case where a tracking device was put on a car that was thrown out. The evidence that was collected from that was thrown out. And you can see that Justice Sotomayor, in her concurring opinion, which really was then also the basis for the full court opinion in Carpenter, in that, beforehand, what was really being protected was a person's privacy interest. It was the information, it was actually the content of the messages that were important that had to be collected. Information that was released publicly or shared with third parties, the jurisprudence was that you no longer had a privacy interest in that. But the nature of the data that is now available has changed that equation. Right. And so the majority opinion in the Carpenter case, basically in throwing out that third party doctrine, which was if you give your cell phone provider, your internet provider information, customer information, location information, the provider could then share that with law enforcement and with the government. But in Carpenter, at least when it comes to cell service location information, they stated that cell phones and services they provide are such a pervasive and insistent part of daily life that carrying one is indispensable to participation in modern society. So now we're at this point that the data that is generated by the use of these technologies, individuals also have a privacy interest in that. And so how are we going to protect that? And if you remember back to 2014, as a result of the Snowden leaks, President Obama issued Presidential Policy Directive 28, essentially trying to lay out some sort of protection of privacy interest for people, for non-US persons, for people outside the United States. Because again, I mentioned before, the domestic law was really focused on geography and citizenship or residency. A lot of these intel oversight and intel restrictions, collection restrictions, protected US persons, but not those individuals living overseas. So I mentioned before, another challenge is the authorities to conduct these operations. Why do many people believe that the US government is not being as proactive in this area in conducting cyber and information operations as they should? I mentioned before that the authority to conduct those operations is based on the purpose. So we look at what the purpose of the activity is, who's going to conduct it, where it's going to be conducted, and especially with cyber and information operations, where the effect will be felt, which could be yet a third geographic location. And we see now, again, that through the development of these different technologies, we may use several different ones for several different purposes. Are we using that signals intelligence collection to meet an intelligence requirement? Are we doing it to simply map a network for a future cyber operation? So the authority to conduct that and the rules and how we conduct that would differ depending on how we what the purpose is, how we frame the operation or the activity. Congress obviously has become frustrated with what they see as being kind of the lack of effort, or the US, the DoD and the rest of the executive agencies being a bit behind. there was always this debate as to whether activities that are taking place outside of an active combat zone or an area of active combat would be a covert activity and thus fall under the authority of the CIA. They would need a finding to conduct, or could the military conduct it pursuant to an execution order issued by the Secretary of Defense? And there was this debate as to whether clandestine cyber and information operations conducted by the Department of Defense outside of those areas of active conflict really were more covert actions. And so in the National Defense Authorization Act for fiscal year 2019, Congress passed 10 USC 394, which explicitly declared that clandestine military activities or operations in cyberspace shall be considered a traditional military activity for the purposes of the cyber or the covert action statute. And so that's the exemption, traditional military activity from the covert action statute, that if it's a traditional military activity, it falls into the authority of the Department of Defense. And then the next year, in fiscal year 20, Congress passed 10 USC 397, which essentially did the same thing for operations in the information environment. So we now have at least a declaration from Congress that those types of activities that are taking place outside of an active combat area are within the authority of the Department of Defense. Why is that? Again, kind of bring it back and wrap it up here. These new technologies, especially when we're talking about information operations and cyber operations, take place in that gray zone. You've probably heard that term before. That gray zone between what we normally thought of as being war and peace, those activities that are kind of delineated by international law. And that was really based on protecting industrial age interest of states and the individuals within the domestic states. And so how does information cyber operations threaten our interest? Obviously, they can cause a lot more damage than when these laws were first developed. We have obviously good capabilities in this area. Why aren't we using those to protect our interests, to defend forward in the case of some of the cyber operations? And it really is a matter of us in trying to get our laws, our regulations, and our authorities caught up to deal with this change in how we conduct operations in the information environment. So with that, I'll wrap up and take questions after I stop sharing my screen here. All right. So questions. Oh. So Samuel Vissner. Right. This slide appears to reflect the international system as the U.S. views and accepts it. One of today's intelligence challenges is understanding how countries with different understandings and views of their own national interests and how they want the international system to function view what is wrongful in the international system. That's obviously correct. So the structure itself of the slide is kind of I think is a commonly accepted international view. However, I mentioned, right, it's fact specific. So what those threats actually are and where they fall in those different zones are going to depend on exactly what you state, right? Their views, other states' views of their own national interest and how they understand that to be. So an excellent example is cybersecurity. So when the United States talks about cybersecurity and trying to get an international agreement on cybersecurity or discussions in at the UN on cybersecurity, we're very focused on intrusions and malicious acts, theft of information, especially economic information, but also government information. It's very focused. Our view is very focused on ransomware, criminal acts, and that is, we want other states to take action against individuals within their borders that are committing those types of activities. Russia and China are much more focused on information, the use of cyber capabilities to deliver information. They want to be able to control the information within their borders and be able to prohibit other states from intervening in that way, from either broadcasting, so in Radio Free Europe, some of the other informational activities that we've undertaken. So we have different interests and we have different views of what cybersecurity really is and what we need to do to protect our cyber systems in each of our countries. And I think that's one of the better examples of that. I hopefully, Samuel, that answered your question. If not, you can follow up again. So Holly has a follow-up question. And she asked that the author recommends, or states that the author recommends that DIA should be permitted to continue purchasing publicly available data on the condition that its activities using this data be subject to routine audit by the Privacy and Civil Liberties Oversight Board. Yesterday, the redacted version of a dissenting commentary by a PCLOB, Privacy and Civil Liberties Oversight Board member, on their review of the X key score was released. It suggests that the board has essentially been co-opted by the agencies it is tasked with reviewing. Could you please comment on the need to strengthen review and oversight bodies in line with cyber operations and OSINT use? Yes. So again, this is part of that balancing that goes on. As we discover, and I think the use of emerging technologies, it really underscores this point, that the need to continue to monitor and to adapt how these are being used, because obviously their use changes. We adapt the technology to meet the new threats or the new needs that we have for collecting information or conducting operations. So it is important, but I think more importantly, as we start to develop this new technology, I think it's important to do so with an eye towards how it's going to be used, so that we can think about how we're going to conduct our oversight and control of the use of that technology before it's actually fielded. I usually frame it as that technology itself is not illegal. It's just how it's used. So we wouldn't want to not, basically develop new technology and continue to develop the AI in these different areas, whatever the other emerging technologies may be, just because of the fear that it might be used to abuse, an individual's rights or violate privacy rights. But rather, we should be thinking about during its development how we're going to exercise oversight of that. Because again, we may need that capability in the future, and to not develop it because of a fear of an illegal use, I think is the wrong direction. And again, we could balance it out better by integrating those concerns up front. So Rebecca Winston has a question. Is it time for a convening of international leaders to discuss what can and should be allowed regarding non-state related actors, such as groups that avoid a national identity or are attempting to create their own definition of what an international entity should be? I think that kind of goes back to Samuel's question earlier, in that everybody, I think, agrees that that probably needs to be done, but I don't know about the sincerity of all international leaders in that approach. So President Biden recently spoke with President Putin, and one of the concerns, obviously, is that a lot of these ransomware attacks are taking place from Russia by Russian criminal organizations. But as reported in the media, a lot of these criminal organizations have ties to the Russian intelligence or the Russian government. And so a lot of these countries, in particular Russia, right, use these surrogates, if you will, criminal actors, non-state actors, to carry out some of their activities, again, to provide some sense of deniability, so that they can avoid some of those reactions. So if it's a prohibited intervention into the domestic affairs of another state, but it's done by an individual who just happens to be located in Russia, there would be no state responsibility by Russia unless they were directing that operation. So this is, obviously a tactic that states who want to benefit from these activities but try to deny them to avoid the responsibilities often use. So I don't think that this would be a very successful effort. So, okay. So there's a question in the chat too from Chris Bailey. We could also discuss the principle of self-determination in this category. Chris, I guess I'm in which category are you talking about? I don't know exactly which, but certainly, if we're talking about self-determination in some of the international disputes, that I don't know if you can type another question or message. I might be able to try to clarify that. But Dr. Zika, I don't know if there are any other questions. You can wait a second here to see if Chris wants to follow up.
Yes, I don't see any other ones either.
Oh, okay. Here's he's followed up here. So he follows up with Christopher. Arguably, election interference is a violation of that right. Correct. So this is, I think if we look at election interference and what took place in 2016, and then fast forward to what took place in 2020, it really highlights this need to adapt both domestic and international law to how technology changes, both changes the threats to our interests and security and changes how we can respond to them. So I mentioned before that kind of the agreed upon line in this, whether interfering in an election would be a prohibited intervention is the changing of actual votes, right? And that the use of propaganda or information operations to try to persuade a population to vote a certain way would not be a violation of that. However, I think, beforehand, when this principle was developed, how would a state interfere in the election of another country? How would a state try to use propaganda to threaten the national security interest, right? They would have to actually physically go to a location, usually, and supply money to an organization that would then either support a party or an individual in an election. So that individual, whether it's a actual agent of a foreign intelligence service or whether it's a someone who's been recruited in the United States to do that on behalf of the foreign intelligence service, right? They would be physically present. They would be subject to the criminal jurisdiction of that state. If they wanted to actually spread propaganda, they would have to take out newspaper ads, television, radio ads. Right, really one of the reasons why the Foreign Agents Registration Act requires, basically registration and reporting of activities undertaken on behalf of a foreign government. This is how we kind of approach this information threat in the industrial age. If anybody's familiar with Operation Infection, the actual operation name was Operation Denver, but this was the KGB and East German Stasi effort in the 80s to blame the United States, to say that the United States had created the AIDS virus, and it was a biological warfare program by the United States, right? That started with a small article published in India in an independent newspaper and took about 2+ years to actually spread around the world before it was reported on the news in the United States. That can be done within seconds now. Nobody has to travel anywhere. They can do it from their troll farm in St. Petersburg. And so, how do we respond to that? The old ways of trying to protect our security and enforce our laws in that area are changed. The threat is much greater, and we have a lesser ability to try to control or affect that or prevent that. So, this is something I think that, we need to think about both on the domestic side and the international side, that maybe what a state can do to respond to those acts that fall under the level of an armed attack or use of force needs to change. So, Christopher, I hope that helped. And I think I'm out of time, or I got a couple minutes left, right, Dr. Zika?
Yeah, but I don't see any more questions.
Okay.
Is that the case?
That's what I see, yep.
Yeah, okay. Well, let's take advantage of a few moments and move ahead then. Thank you very much
Thank you.
for that very informative description of the legal challenges. Quite formidable, really.